Hey guys, so I just wanted to record a reading of the short essay questions so that you guys can do them at your own pace and you don't have to, you can go through this video and pause it as you need to. So for the first one, we're going to look at these two documents, and I know that they're both marked set 2, so just match up what you have with what I've got here. So it says the task is to read and analyze the following documents, applying your social studies knowledge and skills to write a short essay of 2 to 3 paragraphs in which you describe the historical context surrounding these documents. So what's happening in history at this time that leads to the need to create these documents or the creation of these documents. And identify and explain the relationship between the events and or ideas found in these documents. So is it a cause and effect relationship, a similarity and difference relationship, a turning point relationship? That's what you have to figure out. Okay? So when we're looking at these documents, we have document number 1 here. And document number 1 is the 15th Amendment. Okay? So the 15th Amendment. So we're looking at the 15th Amendment, and it says right here that it says the right of the citizens of the U.S. to vote shall not be infringed or should not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. Okay, so it's saying the right of citizens to vote shall not be denied based on your race, your color, or your previous condition of servitude, so whether or not you were a slave in the past. Okay, and the Congress has the right to enforce this power. So we have to think about, what's the historical context around the 15th Amendment being created? Why did we need to create it? What had just happened in terms of, Americans, or a large group of Americans, that we then had to make some rules about who was allowed to vote? Okay. Document 2 is a little bit different. So I'm going to scroll down. I want to look at the source first. So it says the Constitution of the State of Louisiana adopted in 1898. Okay. I know that the 15th Amendment was created before that. I want to say 1870s, 1860s, not quite sure. So we're looking at after the 15th Amendment was created. Okay, so let's take a look at this. It says, if he shall not be able to read and write as provided by Section 3, then he shall be entitled to register and vote if, at the time he's registered, he is a bona fide owner of property assessed to him in this state at a valuation of not less than $300, and on which, if such property be personal only, all taxes due shall have been paid. Okay, so we're basically saying here, okay, if he is not able, if the person trying to register to vote is not able to read and write, they can still register to vote if they're an owner of property. So they need to be a property owner at this point. Property owner of property more than $300, which is a lot of money at this time, and where all the taxes are already paid. Okay? So if you could not read or write, then you, if you couldn't read or write, then you were going to be denied the right to vote. So we know this as literacy tests. Okay, so this is an example of, we have these literacy tests, and then they say, but if you own property, you're fine. So let's think, I want you to just take a second and really think about what group of Americans or what group of people in the United States might be targeted by something like this, where they might not be able to read or write and they might not own property, so therefore they cannot vote. Okay. Next, we're going to look at this next section. It says, no male person who was on January 1st, 1867 or any date prior thereto entitled to vote under the Constitution or statutes of any state of the U.S. wherein he then resided, and no son or grandson of such person, not less than 21 years of age, at the date of this adoption of the Constitution, and no male person of foreign birth who was naturalized prior to the first day of January 1898, shall be denied the right to register to vote in the state. Okay, let's stop there. So we've got a lot of kind of conditions going on here. So if they were entitled to vote before 1867, then they can vote. All right. So let's think. All right. So only people who were able to vote before 1867 are going to be kind of just let in. They don't have to take that literacy test. They don't have to do anything like that. Also, any son or grandson of any such person. So any son or grandson of a person who was entitled to vote before 1867. And any male person of foreign birth who was naturalized, basically made a U.S. citizen before 1898. All right? So they're saying, okay, you have to take a literacy test unless you were able to vote before 1867 or you were the son or grandson of someone who was able to vote before 1867. So again, we got to think about what types of people are going to be able to benefit from this. And this is called a grandfather clause. This says, if your grandfather could vote, then you could too. Well, not everyone's grandfather could vote. Let's think about a group of Americans whose grandfathers weren't able to vote. And it says, a separate registration of voters applying under this section shall be made by the registration officer of every parish. The registration of voters under Section 5 shall close on the 31st day of August in 1898, and immediately thereafter, the registration officer of every parish shall make a sworn copy in duplicate of the list of persons registered under this section, showing in detail whether the applicant registered as a voter in 1867 or prior thereto, or as the son of such voter or the grandson of such voter, and deposit one of said duplicates in the office of the Secretary of State, and the other said duplicates shall be by him filed in the office of the clerk of the district court of the parish. So it's basically just saying, if you meet these qualifications, here's how you can register to vote. All persons whose names appear on said registration list shall be admitted to register for all elections in the state without possessing the educational or property qualifications prescribed by this Constitution, unless otherwise disqualified. If they are on this list, then they're able to vote. And all persons who do not, by personal application, claim exemption from the provisions in sections 3 and 4 of the article before September 1st, 1898, shall be forever denied the right to do so. If you do not, I'm not on the right thing. If you do not apply to get an exemption or an exception to this rule, you will never be able to vote. So, let's keep in mind, so we're looking for either cause and effect, similarity or difference, or turning point. This document happened first, then this document happened. Okay, document 1 came first, then document 2 came second, so let's think about that too. We got some obvious differences going on between here, but obvious similarities. So both of these have to do with the right to vote, okay? And we have to think about, what do you know from your background knowledge of who this might be targeting? So take that information and go ahead and write your little short essay of just 2 or 3 paragraphs, okay? Remember, if you're talking about similarity and difference, you can do like a little introduction with the historical context. So that would actually be a good thing to kind of get down here. So you might want, so your first paragraph is going to be your historical context. Your second paragraph might be your similarity or your cause. And then the third paragraph might be differences. Or the effect, depending on which essay you're doing. Okay? All right, so take this information, and we'll be back with the second one in a second, so you might want to pause this. All right, so now we're going to take a look at this other set. So we have documents 1 and 2 here as well. All right, so in this case, we're going to describe the historical context surrounding documents 1 and 2. We're going to analyze document 2 and explain. I do this every time. We're going to analyze document 2 and explain how audience, purpose, or bias or point of view affects this document's use as a reliable source. Is it reliable? Can we count on it to tell only the facts? So, I'm going to look at the source first of document 1. So this says it's from South Carolina's Ordinance of Secession. So this was South Carolina saying they're going to separate from the Union or from the United States. Okay. So that's what this is. And it says, on the 4th March next, the party, the Republican Party, will take possession of the government. It has been announced that the South shall be excluded from the common national territory, and that the judicial tribunals shall be made sectional, and that a war must be waged against slavery until it shall cease throughout the United States. So they're saying that when we have this next political party take power, that the South is going to be kicked out, the judicial tribunals are going to be made sectional, they're only going to vote for what the North says, and a war is going to be waged against slavery because they're going to try to get rid of it. Okay? The guarantees of this Constitution shall no longer exist. The equal rights of states will be lost. The slaveholding states will no longer have the power of self-government or self-protection, and the federal government will become their enemy. We therefore, the people of South Carolina, by our delegates in convention assembled, appealing to the Supreme Judge for the world for the rectitude of our intentions, have solemnly declared that the union heretofore existing between this state and the other states of North America is dissolved. The state of South Carolina has resumed its position among the nations of the world as a separate and independent state. They are leaving. They are not going to be part of the United States. They are going to be a separate nation of their own, with full power to levy war, conclude peace, contract alliances, establish commerce, and to do all other things, acts and things which independent states may of right do. So they're essentially saying South Carolina is not only just going to be a state, it's going to become essentially its own country. All right, not going to be part of the United States anymore. That's what they're saying in their Ordinance of Secession. Then we'll look at document 2. So I always want to look to see what the source is before I even read it. So I'm looking down here. I see that this is Abraham Lincoln, and we know that his goal is to keep the Union together, and he does not want to see these southern states secede. Okay, so remember, we're going to be analyzing document 2 and explaining how either audience, purpose, bias, point of view affects whether or not we can consider this reliable. So we really have to think about whether or not this is going to be a reliable source and why, or why not. So document 2, it says plainly, the central idea of secession is the essence of anarchy. Okay? If a state secedes, they are essentially just saying, you know, we are lawless, we will not stay, we will not listen. A majority held in restraint by constitutional checks and limitations, and always changing easily with deliberate changes of popular opinions and sentiments, is the only true sovereign of a free people. Whoever rejects it does, of necessity, fly to anarchy or despotism. So it's saying a majority held in restraint by constitutional checks. So only a democracy that's ruled by the majority is a sovereign and free state. Otherwise, they're just kind of falling to, you know, any kind of ruler. It could fall into anarchy. Unanimity is impossible. The rule of a majority as a permanent arrangement is wholly inadmissible, so that rejecting the majority principle, anarchy or despotism in some form is all that is left. Basically, we can't get all the states to agree to everything, right? So we need to just rule a majority. Okay? This is saying a unanimous vote is going to be impossible. The rule of a minority is inadmissible. So we need to just go with what the majority says. Why should there not be a patient confidence in the ultimate justice of the people? Is there any better or equal hope in the world? In our present differences, is either party without faith being in the right? If the almighty ruler of nations with his eternal truth and justice be on the side of the North or on yours of the South, that truth and justice will surely prevail by the judgment of this great tribunal, the American people. In your hands, my dissatisfied fellow countrymen, and not in mine, is the momentous issue of civil war. So he's saying, in your hands, goodness heavens. In your hands, Southerners, not in mine, is the decision over whether or not we're going to go to war. The South is the one who needs to make the decision. It says the government will not assail you. We're not going to get in your way. We're not going to attack you. You can have no conflict without you yourselves being the aggressors. You have no oath registered in heaven to destroy the government, while I have the most solemn one to preserve, protect, and defend. And we've talked about this before, right? That's Abraham Lincoln's idea that he needs to preserve, protect, and defend the Union. And it's saying that it's in the hands of the South if they want to go to war. The North is not going to, and the U.S. government is not going to issue war and declare war on the South. Okay? So, again, describe the historical context around this. Why was South Carolina trying to secede? Why did Abraham Lincoln have to make this, write this piece? Okay? And then look at document 2, so right here, and the Abraham Lincoln one, and explain how audience, purpose, bias, or point of view, doesn't matter, or point of view affects this document's use as a reliable source of evidence. Is it reliable? Can we rely on Abraham Lincoln's word? Why or why not? Think about what his point of view is going to be here. Is he going to have bias, or is he kind of going to take the middle road? That's what we need to decide. Okay, so take some time to dig through those and write your essays.